Good morning, everyone. Good morning to everyone here. Good morning, everyone. To everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online through Nellis or through our legislative YouTube channel. With that, Committee Secretary, please take the roll.
Dahlia. Here. Gonzalez. Gray. Hanson. Here. Hardy. LaRue Hatch. Here. Marzola. Present. Moore. Here. Nadeem. Orntlicker. Here. Roth. Here. Urick. Here. Chair Miller.
Here, and please mark Assemblymember Gonzalez absent excused. With that, just a few reminders that asking everyone to turn down the volume on their electronic devices. You will see members coming and going as members are still presenting their own bills in other committees as well. I will provide the phone number and meeting ID right now for those who wish to testify or make public comment over the phone today. The phone number is 1-669-900-6833. And the meeting ID is 824-979-77533. Anyone making public comment or testifying on a bill today, we ask that you keep your comments to 2 minutes each. And of course, before you speak, that you state your name and also spell it so that we have it correct for the record. Those presenting bills, we ask that you keep your presentations to 15 minutes each. With that, we do have a work session scheduled in addition to our bill hearings. So we will go ahead and begin with our work session right now. So I will turn it over to our policy analyst.
Thank you, Chair. For the record, Cesar Melgareo, Committee Policy Analyst, and as nonpartisan LCB staff, I can neither support nor oppose any of the measures that come before this committee. The first bill in the work session is Senate Bill 60, which revises provisions governing crimes committed against older or vulnerable persons. It was sponsored by a Senate Committee on Judiciary on behalf of the Nevada Silver-Haired Legislative Forum. And there is an amendment submitted by Angela Knott, Deputy Public Defender, Washington County Public Defender's Office, which was discussed yesterday during the bill's hearing, which is to amend the bill to limit the sentencing enhancement for certain acts that constitute theft to cases where the offense is committed intentionally and knowingly against a person who is 60 years of age or older or a vulnerable person. And Chair, that's all the amendments.
Thank you. Members, any questions? Not seeing any questions, I will entertain a motion to amend and do pass. So moved. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Hanson. Any additional comments or questions? Assemblymember Hanson?
Thank you, Chair, and just thanks for the amendment. Appreciate that. That gets me to a yes, and appreciate the work on this.
Thank you so much. With that, oh, I should ask, anyone else? Okay, all those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will assign that floor statement to Assemblymember Hanson. You're welcome. Senate Bill 85, please.
Senate Bill 85 revises provisions relating to public safety. Is sponsored by the Senate Committee on Growth and Infrastructure on behalf of the Joint Interim Standing Committee on Judiciary. And Chair, there are no amendments for this measure.
Okay, thank you. Members, any questions? Not seeing any questions, I will entertain a motion to do pass. So moved. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Dahlia. Members, any additional questions or concerns? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Nay. Hands up for the nays, please. Okay, I have Assemblymember Hanson, Urick, Cole, Gray, and Hardy. All right, thank you. With that, the motion passes, and I will assign that floor statement to Assemblymember Dahlia. That concludes the work session for now. With that, aren't we all so excited to be here to our first Saturday? All right, so let's get the Saturday morning going. So with that, our first bill hearing will be Senate Bill 309, which revises provisions relating to crimes. So with that, I welcome Senator Steinbeck. And co-presenters, as I see we have some co-presenters down in Las Vegas as well. So again, just introduce your team, asking everyone again to remember to state their name and spell it the first time you say it, and of course, state your name before you speak each time. And with that, Senator, your hearing is open. Please proceed.
Thank you, Madam Chair. Thank you, members of the committee. I appreciate your time this Saturday morning. For the record, my name is John Steinbeck, and I proudly represent Senate District 18 in Clark County. And I appreciate this opportunity to present Senate Bill 309 today. This bill proposes various changes to the prohibition of driving under the influence of intoxicating substances. I'm joined here by Jeff Rogan to my left, and we have Carly Helbert and Mark Scifalacqua in Las Vegas. So driving under the influence is, as we all know, a terrible offense. The average car is 4,000 pounds it weighs 4,000 pounds and can do some incredible damage. I'm very passionate about this topic. This was something that I worked on very hard as in the fire department. I worked for a department for 35 years. For 17 of those years, my specialty was technical rescue. My unit was the one that went out on the worst of the accidents to perform extrication when it went beyond the abilities of the local stations. So I have certainly been on my fair share of accidents that are caused by driving under the influence. To speak quickly to a couple of those, just to give this some context, I was first one on the scene to Jessica Williams' accident, so that was the one that was on the I-15 in which we lost 6 children that were cleaning on doing their work service. They're on the side of the highway, and 5 were dead right when I got there, and 1 we worked the hardest that we possibly could, but she did not have a chance. Unfortunately, that lady made a choice that day that cost them their lives. So, as stated, this is a topic that's very important to me. I could go on and on about different calls throughout the years, and I know that all of you certainly have personal experiences that have been touched by this type of very terrible but preventable behavior. We have far too many deaths and injuries that result from DUIs, and so this is why we brought SB 309 here to make 3 changes to Nevada's DUI laws. SB 309 raises the mandatory minimum sentence for a DUI second offense from 10 to 20 days in jail. This aligns with the penalty for DUI. This aligns with the penalty of a second offense for a domestic violence second offense. It also moves a requirement for mandatory alcohol evaluation from a BAC of 0.18 to a BAC of 0.16. And my co-presenters will speak to these a little bit more in depth. And finally, the bill removes the loophole when someone is currently in a court-ordered DUI treatment program and has another DUI. I'd like to now turn it over, with your permission, to Mr. Jeff Rogan.
Good morning, Chair Miller and members of the committee. My name is Jeff Rogan, Jeffrogan, and I'm here today on behalf of the Clark County Office of Traffic Safety. And I'm here just to speak with you briefly about some current trends involving DUI crimes and the DUI Specialty Court program that we have down in the Las Vegas Justice Court, to provide you with some context for your evaluation of SB 309. First, even with all of the public education about the dangers of driving under the influence, DUIs remain a problem within Las Vegas, the jurisdiction of the Las Vegas Metropolitan Police Department. And so that's unincorporated Clark County in the city of Las Vegas. And these statistics are from that jurisdiction. From 2017 to 2024, DUI arrests steadily increased in that jurisdiction. In 2017, there were 4,034 DUI arrests. In 2024, which is the last year we have statistics for, that number stood at 6,159 arrests, a substantial increase of over 2,000. While these numbers can be indicative of an increase in enforcement, the sheer volume of DUI arrests is telling about the scope of the problem of DUI. The numbers of DUIs resulting in a fatality are also concerning. After trending downward for several years from 66 fatalities in 2017 to 22 DUI fatalities during the COVID lockdown of 2020, the number of fatalities jumped back up to 76 in 2021 before receding somewhat to 65 the following year, 69 in 2023, and 56 in 2024. It's important to stress that impaired driving remains a leading cause of traffic fatalities within the jurisdiction of the Las Vegas Metropolitan Police Department. There is some good news, though. Appropriate screening and assessment of DUI offenders and subsequent treatment programs can substantially reduce recidivism rates. This is borne out by our DUI treatment program in the Las Vegas Justice Court. In that court, first and second time DUI offenders can participate in a program of treatment to address the underlying causes that lead to a person's decision to drive while intoxicated. This program has had a track record of success. As of January 2025, the recidivism rate for offenders, looking back 3 years, who have partially or totally completed the DUI court program remains very low. In 2022, there were 47 people discharged from the DUI court, and in the last 3 years, only 4 have been arrested for DUI or traffic-related offenses. In 2023, that number was 3 out of 38, and in 2024, just 2 out of 29. So in conclusion, this snapshot of information should indicate to you that DUI is not an intractable problem. Appropriate screening, assessment, and treatment of DUI offenders in our justice system can be part of a solution to reverse these troubling statistics and lead to safer streets in our communities. Thank you.
Thank you, Madam Chair. I'd now like to turn it over to Carly Helbert in Las Vegas.
Thank you, Senator. And I believe we might have an accompanying PowerPoint as well. If not, this is Carlene Helbert, Carlena Helbert for the record. I'm the Assistant City Attorney for the Las Vegas City Attorney's Office. And again, just a background for the impetus of this bill. The annual report of the Nevada Judiciary Appendix reported more than 10,000 driving under the influence criminal filings in 2024. DUIs continue to be a significant public safety issue. This amendment has been significantly tailored to address the highest risk offenders, namely those with high blood alcohol contents and prior convictions. It passed unanimously out of the Senate with these amendments, and I believe with the stipulated removal of the phlebotomist provision, the Clark County Public Defender's Office also withdrew its opposition. The first provision is the increased DUI second offense penalties. While therapeutic interventions are valuable tools in addressing the root causes of impaired driving, they are not always sufficient for individuals who repeatedly choose to drive under the influence. When a defendant has already been convicted of DUI and afforded the opportunity to engage in rehabilitative programs, a subsequent offense demonstrates a clear disregard for the law, public safety, and the tools previously provided to support behavioral change. This DUI second offense penalty increases the mandatory minimum sentence from 10 days to 20 days. According to the Nevada Highway Traffic Safety Administration, 30% of drivers convicted of impaired driving have had prior DUIs. Drivers who have had prior DUI convictions are overrepresented in fatal crashes and have a greater relative risk of involvement in a fatal crash. And on average, according to the Center for Disease Control, in 2010, a person will drive impaired 80 times before their first arrest. Studies indicate that that number may be higher now. But think about that. That means a person with a DUI second offense has elected to drive 160 times while impaired, putting the public at risk. It's noteworthy that the defendants are aware of this enhanced penalty. When defendants are canvassed during their first DUI sentencing, they are noticed of the increased penalties. By statute for a first offense, and this will not change, they are required to attend a department-approved education course on alcohol or substance abuse and attend a victim impact panel. Therapeutic options have already been given to this defendant. They have been thoroughly canvassed by the court with representation, letting them know that you have been convicted. If you do so again, jail is now an option. Driving while impaired is not a mistake. It is a conscious decision that endangers lives. And when someone reoffends after treatment-based sentencing, it is no longer just a question of addiction. It becomes a question of accountability. The community has a right to be protected from individuals who continue to pose a danger despite being given resources and warnings. Additionally, this second offense penalties makes it more consistent with Nevada battery domestic violence second offense penalties. In 2019, this legislature increased the minimum mandatory sentence on a BDV from 10 days to 20 days. And as a result, the city of Las Vegas saw a 26% decrease in battery domestic violence second offenses. That's what SB 309 seeks to do, decrease DUI second offenses by 26%. It also aligns us with other states, including Arizona, that has 30 to 90 days, depending on the blood alcohol level, Washington, that has 30 to 45 days, and Delaware, that has 60 days for a second offense. Notably, if a defendant chooses to avail themselves to a DUI specialty court, the specialty court referenced by Attorney Rogan, the jail sentence can and oftentimes is converted to house arrest so that they can attend additional therapeutic requirements. And per NRS 484C 403, this jail time can also be served intermittently, meaning generally on the weekends at the discretion of the judge as well. Jail should not be the first response, but it must remain an available and appropriate consequence for those who have exhausted less punitive options and still choose to reoffend. In such cases, incarceration serves not only as a deterrent, but as a necessary measure to reinforce that continued violations will not be tolerated. There
Okay,
must be a
ma'am,
meaningful
ma'am,
consequence.
Ma'am,
Yes.
I'm going to ask, is the gentleman next to you, are you also presenting, sir?
I am.
Okay, so I'm going to ask if we could move along, because again, we need to keep our presentations to 15 minutes, but also we have floors scheduled for 10 a.m. today. So, Senate, what time are y'all going in?
11:30 or
Okay,
within
well,
th-
anyways, the
within
assembly,
3
we're
or
going
4
in at
hours of
10,
that.
so 10-ish. So,
We will pick it up, Madam Chair.
thank you so much, Senator. Thank you.
Mark, would you please start now? Thank you, Carly.
Thank you, Chair Miller. Mark Scifalacqua, SCHIFALACQUA. I'm the head of the Henderson City Attorney's Office Criminal Division, and we handle all misdemeanor prosecutions of DUI that occur in the city of Henderson. Thanks to Senator Steinbach for bringing this bill. I will be very brief, and I'll be straightforward with you. The sections I have deal with 2 crimes, and we're looking to amend and provide some additional protections. One is felony DUI third offense. That's when 3 offenses of DUI occur within 7 years. And that's a felony. First 2 are misdemeanors, third is the felony. That's what we're talking about. Now with the felony, a sentencing judge has 2 options, prison or something we call the Serious Offender Program or DUI court. Very good program, 3 years long, residential treatment, our one last shot to see if we can turn somebody around on the felony. They plead guilty to the offense, they apply, and then they're given some very strict sentencing conditions to keep them out of prison. This first proposal just simply seeks to close a loophole in the law. When somebody pleads guilty to DUI third, we don't go backwards in Nevada as far as sentencing enhancements. But because the sentence is deferred or stayed, there's not an actual judgment of conviction, even though the defendant has pled guilty. So this is to protect against the situation where someone is in the program, commits a new DUI offense, a 4th. It's so the 4th can be treated as the 4th. Typically, like I said, a judgment of conviction needs to be entered. This is simply closing that loophole. A 4th offense would be a 4th offense, not a 3rd offense, and that's in sections 12 and 13. And the very last section I have, Chair, and thank you so much, is regarding blood alcohol content. Now, this is for our DUI first offense, our misdemeanors. What we're trying to do here is get as many people the help they need who could be at risk for an alcohol or drug dependency issue. And we're trying to do that so we don't get to the 3rd and the 4th with those enhanced penalties in prison time, because there's very little we can do at that point. Regarding this, right now it's at a 0.18. If you're over a 0.18 on your blood alcohol content, it's about 9 to 12 drinks in a setting, then the judge needs to order you to go to an evaluation to see if there's anything we can do as far as treatment. And then a report will be prepared for the judge. And the judge can then sentence the defendant. This would move it simply to 0.16. That's twice our legal limit in Nevada. We're still talking around 9 drinks in a setting minimum. And we want to see if we can intervene at that point and create some individualized treatment. We're trying to help individuals at this point not get to the second, not to get to the third, and certainly not get to the fourth. And we believe this would be a good tool. I'll certainly be available for any questions, but I do want to thank Senator Steinbeck, as well as yourself, Chair Miller, and the Assembly Judiciary Committee for hearing this important bill.
Thank you, Mark. This is John Steinbeck for the record. Thank you, Madam Chair. We could, of course, go on and on about this, but we are ready for questions.
Thank you so much. I appreciate your presentation and, of course, bringing forth this thoughtful bill. With that, we will open up questions, beginning with Assemblymember Gray.
Thank you, Chair. Good morning, Senator. Great bill. Something I absolutely could support, but I wanted to make sure on that, when you enter a plea of guilty on your third offense, so the fourth can be treated as a, as a felony regardless, does that conviction, even though it's a deferred judgment, does that conviction go away, or will it stay on there regardless, and, be there for everybody to see?
Thank you. I believe Mark would be the best to answer that, or yes, please,
Yes,
Mark.
Mark Scafalacqua. Yes, it would stay. The benefit to a defendant going through the treatment program that I mentioned is that if they successfully complete it, they actually get a DUI second on their record, not a DUI third. But regardless, if they commit a new one, a fourth, either way, it would be treated as a fourth. So the problem we're dealing with right now is there's this limbo land for a little while they're in the program if they commit a new offense. But if they commit a new offense afterwards, whether or not it was adjudicated as a felony or you went through the treatment program, either way, it's a fourth offense with those enhanced penalties. Again, this would just address the limbo.
Thank you for clarifying that, getting it on the record.
Thank you so much. Our next question is from Assemblymember Ordlicker.
Thank you, Chair, and thank you for addressing this serious problem. I'd like to go to the testimony or presentation on the raising of the penalties, the number of days minimum. And so one thing I heard was this kind of is patterned after domestic violence, and when those penalties were raised, we saw a reduction in violence. So a measurable deterrent effect. And I've also heard that this brings us in line with what other states are doing. So I'm curious about what the data from those other states show about the impact, the deterrent effect. What do the data show from the other states?
We believe Carly would be able to
Hilbert.
answer that the best. Thank you.
Carleen Hilbert for the record. I apologize, Assemblyman. I did not look at the data from the other states. I just looked at the data from our jurisdictions.
A follow-up, please. Yes, please. Yeah, if there are data, that would be helpful. I'd hate to be doing something that doesn't have an effect.
Assemblymember, did you have?
Madam Chair, is John Steinbeck for the record. Assemblymember, we will work on that. Thank you.
Thank you. Assemblymember, did you have additional questions? Please proceed.
Thank you. It is troubling that we have people who are repeat offenders. We criminalize it. They still do it. That's, people do bad things. So another way to think about this, that I know we do, is how can we prevent them from making bad choices with, they can't turn the ignition until they pass the test. Were there alternatives there you thought about to try to address the bad person problem besides just locking them up?
Yes, John Steinbeck for the record, and then I'll turn it over to the team to see if they have any additional answers for this. But the bill was much more encompassing when we first introduced it. Like many bills here, we had to amend it twice to get it down to where it is that you see it today, to get a unanimous vote that we ended up with in the Senate. I am for all solutions, and I made this statement during my when it passed through the Senate on the floor. I'd like to see continuous DUI bills come through, and if it's treatment, if it's education, if it's additional resources, if it's unique technologies, I'm open and I'm ready to embrace any of those and all of those. This particular bill here, I wrote up with the assistance of the people that you see here today. And these are the areas that we were able to address along with those that we amended out. But I'm certainly open to any and all solutions that we can make with this. But deterrent and accountability, I feel, is part of the solution and an important part. But I do want to point out that the alcohol evaluation is our attempt there as well, right? That is not meant to punish people in any way anymore. That is meant to try to reach them and show them this we have some resources there, and that there's a better way to do this. So that is certainly the portion of this bill that is considering that, and Assembly member, of course. So I'm open to all solutions.
Thank you for that. With that, I will go ahead and open it up for testimony and support, beginning here in Carson City.
Morning, Madam Chair, committee members. Todd Inglesby, representing the Professional Firefighters Nevada. I think you heard Senator Steinbeck touch on it. We run these calls on a daily basis. These impaired drivers, we've seen them kill kids, we've seen them kill adults, grandparents, moms, dads. Those are the worst calls that we run on. I think this is a good combination of, like he touched on, getting some early treatment education and trying to change the behavior. But also, if the behavior can't be changed, we have to use other measures to change that behavior, and we support. Thank you.
Morning, excuse me. Good morning, Chair, members of the committee. Warren Hardy, today representing the Nevada Urban Consortium. Understanding that brevity is the soul of wit, I will simply say we thank Senator Steinbeck for bringing this forward and doing the hard work to make this a reality. We do think this strikes a really good balance between offenders and those that are struggling with addiction, and we would encourage the committee to pass the bill. Thank you.
Good morning, Chair and members of the committee. My name is Josh Martinez, representing the Las Vegas Metropolitan Police Department. I'd just like to echo a lot of the same comments that the previous speakers made in support of this piece of legislation. As you know, in Southern Nevada and throughout the state, we're dealing with fatal traffic accidents and collisions. One of the leading causes of those fatal collisions is DUI. So we're always looking to strengthen those laws, but also provide the rehabilitation that's necessary to hopefully help those folks that get, find themselves in those predicaments where they are arrested for DUI to get them to not be the repeat offenders or find themselves in one of those fatal traffic collisions. We support this legislation. Thank you.
Thank you. Is there anyone else here in Carson City? Okay, we'll go down to Las Vegas for support testimony. Please proceed.
Good morning, Chair Miller, Vice Chair Marzola. For the record, my name is Andrew Bennett, and I serve as the chair of the Nevada Advisory Committee on Traffic Safety, also known as NVX.
Please spell your name before you proceed.
Sorry, Andrew Bennett, ANDREWBENNETT. I'm here today to offer strong support for SB 309, specifically Section 11 of the bill, which reflects one of NVAC's top 10 critical policy priorities, which is increased screening and assessment for individuals involved in impaired driving offenses. From a traffic safety perspective, early identification of substance use disorder is critical. By ensuring that more individuals receive professional evaluation, we create opportunities for interventions before tragic crashes occur. This provision supports a public health approach to impaired driving, one that emphasizes treatment and recovery over incarceration alone. Our committee, the Nevada Advisory Committee on Traffic Safety, includes dozens of representatives from state and local agencies, law enforcement, advocacy groups, and public health professionals. As a statewide body, our commitment to reducing serious injuries and fatalities on Nevada's roadways is paramount, and we believe that this bill would help us achieve those goals. Thank you so much.
Good morning, Chair Miller and members of the committee. My name is Nancy Bruni, Nancy-Brune, and I represent Ward 6 on the Las Vegas City Council. I'm here to express strong support for SB 309 because it seeks to address the rising number of DUIs in our state, which continue to be a significant public safety issue. Recently, in the area that I represent, we experienced the tragic death of Mackenzie Scott, who's a high school senior who should have graduated this past week. A week later, our community mourned 23-year-old Jory Odabe, also killed by a drunk driver. And our drunk drivers are not just killing our youth and our residents. They're putting at risk and killing the lives of the people whose job it is to protect our community. 18 months ago, Nevada Highway Patrolman Sergeant Abate and Trooper Felix were killed by a drunk driver. Metro Officer Colton Pulsifer was also killed by a drunk driver. The list gets longer and longer. As Clark County DA Wolfson has said, the possible penalty in these kinds of DUI cases is insufficient. What we're doing so far isn't working. We're having too many kinds of these cases on a daily basis. And we all know the status quo is not working, and we can't keep sitting by and doing nothing. That is not justice. Now, some may state there's a body of research which suggests that tougher penalties aren't effective deterrents of crimes. Admittedly, I'm not well versed in the entire body of research, but I will share that in Arizona in the early 2000s, they adopted stricter DUI policies. In fact, they're considered the state with the harshest DUI policies in the country. And this may speak to your point, Assemblyman Ornlicker. Those stiff penalties have paid off. Between 2005 and 2014, Arizona saw alcohol-related traffic deaths per 1,000 residents fall by 52%, far faster than the 32% decline recorded nationally. Among those younger than 21, deaths fell almost 72%, again, with a larger decline than the national average of 48%. So the data suggests that these sorts of measures do have an impact. I want to close by noting that this bill's a
City Councilwoman, I'm sorry, we have gone over the time. So if you could submit the rest of your comments in writing, so that we can see it in its entirety.
Thank you so much.
Thank you so much. Is there anyone else there in Las Vegas? Not seeing anyone. Broadcasting, please open the lines.
If you would like to testify in support of Senate Bill 309, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony beginning here in Carson City.
Hello, Chair, members of the committee. Good morning. Happy Saturday. Harrison Epstein, legal extern, Clark County Public Defender's Office, Harrison Epstein. Our opposition today is specific and limited to Section 12(1)B, which extends the mandatory jail time from 10 days to 20 days for second DUIs. Instead of jail time, we are failing to consider resources or treatment options that would be better for that person and to curb any sort of behavior that might stop them from driving under the influence in the future. We all have the same goal here. We want to stop this behavior, and our concern is that the person getting that second DUI, while fully understanding they've made choices and need to have consequences for those choices, but changing it to 20 days without any evidence or data to show that will help will only hurt them. We're putting a Band-Aid on a problem that we don't know will actually help heal those wounds. 20 mandatory days in jail is significant. It's enough for a person to lose a job, to fall behind on their rent, their bills, and destabilize someone's life that clearly needs help. We would be stripping people of the support they need in order to curb an addiction they're likely fighting. Thank you.
Good morning, Chair Miller, committee members. Angela Knott, ANGELA KNOTT, on behalf of the Washoe County Public Defender's Office. My opposition on SB 309 is just regarding the .16 and the 20 days in jail. What I heard from the presentation, and I believe Senator Steinbeck mentioned this, is we need to start exploring more solutions. I think it is time that when it comes to the first DUI, I would be interested to see if there's a way we can do better with our treatment programs for first-time offenders. The education programs, I'm not sure the last time any of this was actually updated and addressing more now concerns. Also, I would be interested in the dram shop laws. Are they working in other states? Maybe it's time we look at the data to see where these first-time DUIs are starting their drinking before they get in the cars. Maybe we should be looking at restaurants and casinos to see if we have an issue with over-serving and then allowing someone to get in a car. I think these are just solutions that we should start exploring instead of just punishing when we get to a second time. The problem seems to be the first time, and what can we do to prevent that second time from happening? Thank you.
Thank you so much. Not seeing anyone else here in Carson City and not seeing anyone approach there in Las Vegas. Broadcasting, will you open the lines for opposition testimony?
If you would like to testify in opposition to Senate Bill 309, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I'll open it up for testimony in neutral. If there's anyone wishing to testify in neutral, please approach. Not seeing anyone in Carson City or in Las Vegas. Broadcasting, please open the lines.
If you would like to testify in neutral for Senate Bill 309, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify neutral at this time.
Thank you so much. Then, Senator, would you like to come up for any final remarks?
Thank you, Madam Chair. John Steinbeck for the record. I would, first of all, I have a message here from Sandy Heverly, Executive Director, Victim Advocate for Stop DUI, and she wanted to express her strong support for SB 309, and she was not able to be here today. So thank you. Second, I'd like to clarify that the move from .18 to .16 is for first-time offenders, not just second-time offenders. So that is us trying to move it into treatment at an earlier time, as the opposition just brought up. And finally, I'd like to address something that the opposition said when they said that 20 days in jail is significant. It's supposed to be significant. That's the point. That's what we're doing here. Yes, there'll be loss. You might lose a job. You know what else got lost? We just lost Mackenzie on May 2nd, a young girl who was trying to go to school at Arborview, walking across the street when her killer hit her at 3 times the legal limit in the crosswalk. So the loss should be significant at that second time. We agree, or we obviously disagree. But it has to, that's the point of a deterrent. Now, we understand there's addictions that are involved here. There's lots of people that are addicted to many substances, and my heart goes out to them. I want resources for them, and this is no exception. But you still make choices. And you can have, and many people do, face addictions and still choose not to get into a car. Just like they have addictions and they choose not to shoot a gun down the street. This is a weapon when you get into it. And so those choices are still there. We can still address the underlying conditions, but have deterrents and systems in place to try to protect people like Mackenzie. And with that, I would appreciate your support and thank you for your time.
Thank you so much. And Senator, I really appreciate this bill because it's a challenge, and I feel like you have worked really hard to strike that appropriate balance because we are, for the most part, dealing with 2 different situations. We know that there is substance abuse and addiction, and this may not help those people, right? Because the addiction is in control of what they're doing. And yet we also know drunk driving can also be a choice. It can be someone who's not addicted and just made a bad choice that day and decided to drive when they knew they shouldn't have. And so for at least for those individuals, I believe that we can make an impact. But I appreciate your sensitivity and experience and knowledge in knowing that we need such a robust package and services to provide when it comes to resources, training, accountability, all of those things, so that if we could just eliminate addiction, period, for everyone. So I appreciate that. Thank you so much. With that, I will go ahead and close the hearing on Senate Bill 309. And I will open a work session on Senate Bill 309. As you know, Speaker has waived the rules for us and given us permission. I think it's Rule 54, Section 7? Rule 57, Section 4. I was trying to pretend like, Look, Speaker waived the rules. So I would like to open a work session for Senate Bill 309. Members, any questions? Okay, I will entertain a motion to do pass. I have a motion from Vice Chair Marzola and a second from Assembly Member Cole. Any additional questions about the motion or comments? Assembly Member Roth?
Thank you, Chair. Just given the time, I would reserve my right on the floor.
Certainly. Thank you so much. Assembly Member Gray.
Thank you, Madam Chair. Again, this is a great bill. Had an airman that was on leave in Gardnerville in 2022, I believe it was. Fallon Montanucci was killed by a fourth-time drunk driver. This is, I don't believe for a minute this will prevent anything, but it's about accountability and making folks pay for their mistakes. And then in 2001, my father-in-law was killed as a result of a drunk driver trying to effect the arrest of in a pursuit for him, and he was a multi-time offender as well. So we've got to start holding these folks accountable more and more. So thank you very much, Senator.
Anyone else? Okay, all those in favor, please say aye. Aye. Anyone opposed? Thank you, and the motion passes unanimously. Thank you so much, Senator. Okay, now we will move back into our next bill hearing, which will be for Senate Bill 465. Senate Bill 465 is on behalf of the Office of Finance and the Office of the Governor, and it revises provisions relating to certain criminal defendants. So I'll give you all a few minutes to approach. And are you presenting on your own? Okay, so your hearing is open, and so just whenever you're settled and ready, please begin.
Good morning, Chair Miller and members of the committee. My name is Drew Cross, C-R-O-S-S, and I'm the State Forensic Program Coordinator. Thank you for the opportunity to discuss the reprint of SB 465. I'd like to provide a brief overview and then be available to answer any questions. We have worked closely with the public defenders and district attorneys recently. We've worked closely with the public defenders and district attorneys recently, and the alterations that have been made address their concerns. We appreciate their suggestions and willingness to work with us to improve the statute, which will ultimately lead to a more efficient forensic system. Through this collaboration, it was decided that Section 1 of the bill, codifying involuntary medication, be removed. SB 465 revises the number of evaluations required regarding an individual who has received restoration treatment. Currently, 3 reports are required, but this has shown over the years to be inefficient and not in line with national standards. The bill changes this to 2 evaluations when both evaluators concur in their findings, opinion, and recommendations. If the 2 evaluators disagree regarding an individual's competency to proceed, a 3rd evaluator will be assigned. This will add to the efficiency of the statewide forensic system without sacrificing the quality or impact of reports. The reduction from 3 evaluations to 2 will result in better use of evaluator time and bring Nevada in line with national standards while preserving the safeguards for the quality of the assessments and the fairness of the judicial process. Clinicians who previously completed the 3rd evaluation will now be able to do one of the 2 evaluations required. Simply put, it is more efficient to clinicians, the clients, and the courts to reduce the number of total evaluations required per client from 3 to 2 and is reflective of the current perspective nationwide. Thank you for the opportunity to discuss SB 465, and I'd be happy to answer any questions.
Thank you so much. Members, questions? Not seeing any. I will go ahead and open it up for support testimony, okay? So anyone here in Carson City wishing to testify in support? Not seeing any. One here in Carson City or in Las Vegas. Broadcasting, please open the lines.
The public line is open and working. There are no callers at this time.
Thank you so much. Then I will go ahead and open it up for testimony in opposition. Not seeing any here in Carson City or in Las Vegas. Broadcasting, will you please open the line?
The public line is open and working. There are no callers at this time.
Okay, then I will go ahead and open it up for neutral testimony. Not seeing anyone here in Carson or Las Vegas. Broadcasting, will you please open the lines?
The public line is open and working, and there are no callers at this time.
All right, thank you. Then I will close testimony. Do you have any additional comments? Okay, thank you. Then with that, I will go ahead and close the bill hearing on Senate Bill 465. I will then move into a work session. Members, as we've noted, the rules have been waived, so I am asking if anyone has any additional questions on Senate Bill 465. Not seeing any, I will entertain a motion to do pass. So moved. I have a motion from Vice Chair Marzola and a second from Assemblymember Gray. Any additional comments on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And with that, the motion passes unanimously, and I'll assign that floor statement to Assemblymember Gray. With that, members, thank you so much. That concludes, nope, this is what we're going to do. It doesn't conclude anything. We need to do public comment. So I will invite anyone here in Las Vegas that would like to make public comment. Not seeing anyone here or in Las Vegas. Broadcasting, will you please open the lines?
Chair, the public line is open and working. There are no callers for public comment at this time.
Thank you so much. Then with that, that concludes our business for now. Just in case, because we all know it's just one day until midnight on Monday. So I will recess just to be safe. But with that, we are in recess. Thank you so much.